Would the individual on the Motorola 393-1863 please identify yourself? Mr. Frost, are you here on Bloomfield Financial?
Yes.
Okay. I'm just making sure I know who's in the room. We'll call your case up in about 5 minutes. I don't see Mr. Boatman. Is Mr. Boatman in the physical courtroom? I don't see him in the Zoom courtroom, although I can't identify one of my callers, but we'll call that case in about 5 minutes.
Very good. Thank you.
Thank you. On the Motorola Moto G Stylus cell phone, could you identify yourself, ma'am?
Desanya Murchison.
Say your name again, ma'am. Desanya Murchison?
Yes.
All right. And with the individual on the cell phone 393-1863, please identify yourself.
That is a landline. Robert Boatman, B as in boy.
Robert Boatman. All right. All right. Well, we can call that case. Then we're on the record in docket 05008990. That is Bloomfield Financial versus Robert Boatman. Will the parties please introduce themselves for the record? Mr. Frost, you're on mute.
Yes, good morning, Your Honor. Timothy Frost on behalf of plaintiff.
And sir, you are Robert Boatman?
Yes, sir, I am.
All right, this is the time set for a motion to show cause on Mr. Boatman for a previous fail to appear at a discovery hearing. So Mr. Boatman, do you have an explanation as to why you did not appear on January 17th?
I received a summons to call this number on the 12th, on December 12th of 22 at 8:30 in the morning, which I did. I waited 20 minutes online, and phone message said no one available, and that was the last I heard of it.
Yeah, I have you. And you received your motion. You received your motion and affidavit for show cause today. That's correct.
Yes, I'm looking at it right now. Yes.
I want to find out why you weren't here on January 17th.
I received a.
Hold on. So, Mr. Boatman, you received this at the 63021 Hilliard Road, Lansing, Michigan address. That's why you're here.
Yes, correct.
All right. You also received at that address a notice to appear on January 17th, 2023, at that same address. You also were personally served. You were personally served at that same address.
Yes.
In order to appear It does say December 12th though on that date. I see what you say. I see what you're saying here. That looks like a December 12th date, not a January 17th date. You did receive a notice from the court to appear on January 17th though. That was an adjourned, it looked like an adjourned date. You don't have that notice, do you, sir?
No.
Yeah, we sent notice that the December 12th date was adjourned to January 17th at that
Okay.
Hilliard Road address.
Yes, that's where I live.
Mr. Frost, how did you want to proceed today?
Well, Your Honor, he definitely received the initial subpoena for creditor's exam. And he also received we personally served him with the show cause to appear here today. The subpoena required him to produce documents at least 48 hours prior to the examination. As the court knows, it's difficult to take an effective creditor's exam without the defendant's financial documents.
Right.
So I can try and get as far as we can, but I'm asking for an adjournment at this point because I'm going to need the documents. I need all his bank statements. I need all these documents, and he's got a lot of them, Judge. This man has 31 open accounts, 3 pages of open and current accounts. I've never seen anything like it on his credit report. It's astounding. It's an amazing, amazing credit report. He's got stuff. He's got a lot of documents, and he hasn't provided a shred of documentation at this point. So at this point, I suggest,
Did you want to start a document examination maybe in a breakout room, and then we'll adjourn it for a full to see what you have and what you don't have?
Yes, Your Honor. Yep. And I expect on this one, I expect to be driving to Lansing for the next one to sit down with Mr. Boatman. I would like him there with all of his documents. Yeah.
All right.
This is going to take several hours. Yeah.
Let's do this. But
I'd like to get as far as I can, Your Honor. Yes.
Right. I'll quash the show cause at this point in time. And what I'm going to do is I'm going to go ahead and set it for hearing. And then I'm going to put you in a breakout room, but I'll set it for hearing so we have a date set for a live creditor's exam, and we'll make sure it fits up with your schedule, Mr. Boatman's schedule. So we have you live here. But then I'll put you in a breakout room so you can get started. All right, Mr. Frost?
That sounds good. Thank you, Your Honor.
All right. So let's set this for a live creditor exam. How far out are you thinking, Mr. Frost?
2 or 3 weeks. Well, we do need those documents. I need the documents from Mr. Boatman, so he needs to supply those to us.
Right. So let's do 3. Like the week of the 17th or the week of the 24th. How does April 18th at 8:30 look? And this would be a live, so check your schedule, Mr. Frost, because this will be live to have you both here. I do think you're correct. I think that's the way the transfer of this materials is probably more likely.
Yeah, that's fine, Your Honor. The 18th.
All right. So we'll do April 18th. Mr. Boatman, you have this date?
Yes, April 18th.
Okay, April 18th at 8:30 for creditor's exam. And that's to be live, Mr. Boatman. So that'll be on the 6th floor of the city of Lansing. That'll be 6th floor. Now hold on, and I'll put you in a breakout room, and Mr. Frost can indicate all the material that he'll need on that date or before that date.
Okay.
All right, so we have April 18th at 8:30. Live in-person creditors examination. And then Mr. Frost, I will place you in a breakout room with Mr. Boatman and you can get started on that, all right?
Great. Thank you, Your Honor.
Thank you. All right, I'll have Mr. Frost and Mr. Boatman placed in a breakout room. How are you, Ms. Robinson?
I'm good. How are you?
I'm good. All right, we're on the record and docket 22-02631. That's Orbit Leasing versus Diana Murchison. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Jeremy Chisholm, B74670. I am the attorney of record for the plaintiff.
Ma'am, you are Desana Murchison?
Desanya Murchison, yes.
Right. All right, we are set today on a motion to set aside the default entry, I believe. Let me see. And Ms. Murchison, this was based on your motion, I believe?
Yes.
It appears that your indication is that because of the inconsistency in your housing situation, that that's why you've had problems with your mailing address?
Yes. I was currently staying in the shelter.
All right. Mr. Chisholm, have you had the opportunity to speak with Ms. Murchison about this?
I have not, Your Honor. I do believe Ms. Murchison has talked. I'm corporate judge, just for the record. I'm corporate counsel at Orbit Leasing. And I believe that Ms. Murchison has had an opportunity to talk with some of the people in the legal department, but I have not personally spoken with her.
All right. It appears that she has. It appears that there were some that she did have some conversations. Would you like a second to speak with Ms. Murchison in a breakout room to see just to see if you have the same issues here?
I'd be happy to, Your Honor.
All right, Ms. Murchison, would you be amenable to that? I'll place you both in a breakout room. You can talk a little bit about the case.
Yes, that's fine.
All right, I'll have Mr. Chisholm and Ms. Murchison placed in a breakout room. So you'll get prompted to go to a room on your screen.
Right down the,
And then Mr. Akinicki, I'll call your
right
case
down the
next.
hall, there's a set of stairs.
Okay,
Now it's off to the right, it's the elevator.
okay,
Third floor, room number 1.
thank you.
You're welcome.
Painter, right? All right. Yeah, Mr. Akinicki, we'll call your case and then you just need an adjournment, right? You contacted my staff earlier.
I did. The defendant in this case checked, and one he told me to hold until the 23rd, and the other one I cashed. I'm just waiting to see if they clear. So if we get back in like a week, I'd probably end up. That's if they clear.
All right, let me call the case. It's docket 22-02745, Daryl Painter versus William Anderson. Mr. Akinicki, your presence for the record.
I can turn to the plaintiff.
All right, this time set for a pretrial today, and this was used for a control date. It's my understanding, Mr. Akinicki, that the indication is the defendant has paid in this matter, but you want to make sure that the check is cleared. Is that correct?
Well, he wrote me 2 separate checks, and one I'm actually holding until the 23rd. So I just wanted to make those clear before it's totally. But yeah. So if we could control date sometime down, I'll probably.
All right, let's see a control date for a week or 2. Okay. Oh, we lost him. All right, let's come back to that. Oh, we got him back. Or at least we got something. Mr. Akanicki, you still there?
Yes, I am. Sorry, I'm out at 55th District Court.
All right, so how about we'll set it for March 27th at 8:30. And then you can contact our office to see if we still need that date.
Sounds good. Thank you, Your Honor.
All right, thank you. That's all for the record.
Oh, so you just switch phone?
Mr. Mashney, are you ready on your file?
Yes, I am.
And that's Mr. Kane, who's on Zoom, I believe.
He hasn't connected to audio. I've sent him messages trying to explain how to do it.
All right, so Mr. Mashney, let's wait a second because we can't talk to him right now.
Okay.
Yeah, so we'll wait for the end and then if we can't connect to audio, we may default him.
Okay.
Okay, so I'll give him to the end, but for whatever reason, he's not connected to audio, so we can't communicate with him. And then Mr. Woodrow and Mr. Cozart.
Good morning, Your Honor.
Good morning.
Morning, Judge.
So we're on the record in docket, and you're Mr. Soff, aren't you?
Yes.
All right, you can come up here and have a seat. Yep.
Yeah.
Oh, let me see if I've got this right. I don't see Miss Williams here.
I'm here.
You're here? All right. All right. Go. Let me call a case in front of you and then I'll call your case. All right. You can have a seat there, Mr. Asaf. Mr. Kane is connected. Good. Let's go ahead and go with Woodrow. So we're on the record in docket 2203924. It's LG Everett LLC versus James Murray. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Hugh Woodrow appearing on behalf of the plaintiff LG Everett. I also have Ms. Bessie Clark on Zoom with me, the manager for Superior Management, who is the management company for this particular property.
All right, thank you. And Mr. Cozart?
Yes, Your Honor. Adam Kazord here on behalf of defendant James Murray.
All right, and Mr. Murray's here?
Yes, he is, Your Honor.
All right,
James Murray.
thank you. And sir, you are James Murray?
Yes, I am, sir.
And you can hear me all right, Mr. Murray?
Yes, sir.
All right, Mr. Woodrow, this is the time set for a pretrial in this matter. Legal Services had filed an appearance, and then we set it for today for a civil pretrial. Have you had the opportunity to speak with Mr. Cozart concerning filling out a pretrial statement in this regard? This is a landlord-tenant matter, if I remember correctly.
You're right, it is, Your Honor. And no, I haven't had a chance to talk to Mr. Kozark about that, Your Honor. But as you indicated, this is a landlord-tenant matter, and we have a ongoing concern here with this property. As you can tell, Mr. Murray is in a building that has been red tagged by the city. He's been instructed by the city to remove himself from the building so that proper repairs can be done. It's my understanding there's no power to the building. As you can tell, Mr. Kozark's sitting in the dark, or Mr. Murray is sitting in the dark. He's the only tenant left in this building. And we admit everything in their response. There's nothing to try here. You can summary disposition this right now today. We admit that this place has not been kept habitable. That's the whole point. It's been red tagged, it's been condemned. We need everyone out of the building so we can effectuate the repairs. We can't do them with him living there. I don't even know what the tribal issue is here.
Mr. Cozart?
Your Honor, the tribal issue here is this was filed as a non-payment of rent case. This wasn't filed as termination. I believe the issue of the red tag came up later, so that's the complaint that was filed. That was the answer that was made. So I don't know if Mr. Woodrow needs to amend his complaint for the termination or what needs to be done, but this was non-payment of rent.
And it was red tagged after the action was started, Your Honors, but I can't help that, and neither can my client. So, I mean, if we have to dismiss this just to refile as a termination of tenancy case and delay this another 2 months, I think is overly ridiculous. On the basis of judicial economy, I think the court can take judicial notice of the fact that this has been red tagged, and Mr. Murray just needs to vacate the property so we can fix it. We've offered him other apartment buildings to move into, and he refuses to do it. It's not us condemning him, trying to kick him out. It's the city.
Right. Mr. Kozer, can we, I don't know if you want to meet with Mr. Woodrow. You probably had some conversations with him. Right now, I'm thinking a date certain, date certain would be, I guess we could have Mr. Woodrow amend his information. I'm going to expedite the whole process because this process needs to be expedited. But on the other hand, if Mr. Murray needs a date certain to remove himself, that seems pretty reasonable to me. Mr. Kozer, would you like to speak with Mr. Woodrow and Mr. Murray in a breakout room, or I don't see a reason to set this for trial. There doesn't seem to be any legal issues here for the court for the jury to consider.
Your Honor, may I speak?
Hold on, Mr. Murray, because this is all being recorded and you have a lawyer.
Yeah, I mean, if I could speak with Mr. Woodrow, with Mr. Murray, we'll see what we can get figured out.
All right, I'm going to have.
You want to give us the date, or would you like us to come back?
I'm going to put you in a breakout room, and yeah, I'll put you in a breakout room, and then we'll have you come back to see if we can put it on the record. But I'm going to have Mr. Woodrow, Mr. Kozer, and Mr. Murray placed in a breakout room. Mr. Woodrow, did you need a property manager in there?
Yeah, Miss Bessie Clark, if you could bring her in.
All right, so I have Miss Clark, Mr. Woodrow, Mr. Kozer, and Mr. Murray placed in a breakout room. And then Miss Williams, you can come up here. You can sit next to Miss. Right, we're on the record in docket 2203-928. That is Ahmed Asaf versus Tiffany Williams. This is the time set for motion. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning, Attorney
I'm the owner of the house. 1520 Norwood.
All right, and sir, Mr. Levine, you're here, or Mr. Levine, you're here on this case?
Indeed, Your Honor. Just been notified recently. My understanding is there's a defendant's motion. I haven't had a chance to review it, but to be responsive to the court, yes, on behalf of Ahmed Asaf.
All right, thank you. And then, ma'am, you are Tiffany Williams?
Yes, sir.
Okay. And your indication today is that on the this was a default judgment for failure to appear, and you were in the hospital at that time giving birth.
Yes, I was.
Okay. Mr. Levine, you're indicating you're new on this. Mr. Asaf, is that the first you've heard of this?
Yeah.
Okay. Do you have any medical documentation to confirm that on that February 22nd date that you were in the hospital on that date?
No, I didn't, but I texted his phone also telling him that I was in the hospital having my baby.
Okay, that doesn't help me. All right. What I would need is a medical documentation indicating that on the default day of February 22nd, that you were in, what hospital were you in, ma'am?
Sparrow.
Okay, so it's that you were in.
I was at ICU too.
Okay, so and you must have a myriad of paperwork from that. Have you had the so as long as you provide that to the court, I'll set aside the default. All right, that's a fair request. That if you're in the hospital giving birth,
right,
that I should set aside your default. but I will need some confirmation on that, all right? Do you think that in the next week you could give the landlord or Mr. Levine something in regards to that, or I can just set it out a week?
Okay,
Would that work?
yes.
Let's see if we can set this out a week. Or two, depending on our docket. When I get a look, that means that we're already filled up, so it might be a couple of weeks. But it's a way of keeping this moving with the understanding that they need the paperwork, all right? Oh. All right, so that's March 27th?
Yes.
All right, so let's adjourn this for March 27th. At what time? At 8:30. And ma'am, in the meantime, if you're able to get that documentation to Mr. Soff or to Mr. Levine. Mr. Levine, do you have a contact address that she could maybe email it to?
Sure, absolutely. And I can tell her on the record if the court doesn't mind. All right, ma'am, I hope you can hear me okay. It's attorney, ATTOR. I'm sorry, do you have something to write with?
Yeah, I'll write it down for you. Okay. Attorney.
Thank you, Your Honor. I appreciate it. Yes, Attorney Barnett, B as in Brian, AR, N as in Nation, E, T as in Thomas, Levine, LE, V as in Victory, I, N as in Nation, E, at gmail.com. It's just my direct email.
All right, so I have attorney ATTORNEY Barnett BARNET Levine LEVINE at gmail.com.
That's correct, Your Honor. Thank you.
I don't know if did you give her that already? So if you have any documentation, we may not need that hearing. I'll set it aside and set it, sir.
We'll be on the 27th.
Yeah.
What is it?
March 27th is a Monday at 8:30.
That's fine, because use this.
All right, so it'll be March 27th at 8:30. But if you're able to provide that paperwork, we can set this aside and then we'll reset it for hearing. We defaulted you because you failed to appear, but you seem to have a valid, reasonable excuse. All right. So right now we're set for March 27th at 8:30 next week. All right, Mr. Levine?
Good, I appreciate it, Your Honor. Thank you.
All right, thank you. That's all for the record. Docket 2203928 will be your next Monday.
Okay, thank you.
All right, thank you. Thank you, Ms. Williams. All right, Mr. Mashni, I think we have Mr. Kane on the line here. So, Mr. Kane, you can unmute yourself.
Okay, there we go. Can you hear me?
Yes, we can.
Okay.
Mr. Kozar. Make sure I have the right phone here. 3203. We're on the record in docket 22-0320. That's Kadwa Tafor versus John Kane. Will the parties please introduce themselves for the record?
Raymond Mashni on behalf of the plaintiff.
All right, and sir, you are Jonathan Kane.
John. There's no Jonathan.
John Kane. All right. This is the time set for a pretrial in the. This is the time set for a motion in this matter. This was a motion to. This was initially set as a conditional dismissal. And then Mr. Kane, you filed a paperwork, was never served with any paperwork from Taper. No.
Yeah, I was never served. I just filed it, went and had the hearing, didn't know anything about it. And shadily did the eviction, caused a lot of damage to a lot of my personal stuff while I was up there trying to file the emergency order. They didn't care. I've tried to email some the pictures to you, but I keep having problems. But they destroyed a lot of my private stuff intentionally and willfully.
Let's find out. Okay, so on January You stip and ordered for a conditional dismissal on January 23rd. Is that correct?
What is it?
I have a stip and order for a conditional dismissal on January 23rd.
Yes. Then,
Okay.
after looking at everything after the court hearing was over with, the amounts were wrong.
Did you contact anybody in that regard?
Yes, I did. I tried calling their attorney's office. I sent an email and never got a response. Left a couple of
Did you
messages.
contact the
never got
court
returned phone
indicating
call.
that there was a problem with the conditional dismissal?
To their attorney's office to say, wait a minute, these aren't right. I didn't know what else to do.
Well, I mean, the court's supposed to sign the conditional dismissal. If you had a problem with the conditional dismissal, I signed the conditional dismissal on January 26th, which would be 3 days after the order was presented to that's 3 days after January 23rd. Did you contact the court prior to January 26th?
No, I thought the order was signed the 23rd.
No, well, I orally said that I'd accept the order, but I didn't sign it till the 26th.
I didn't know that.
I
either.
signed it on January 26th, which is 3 days for you to look at it and contact the court to see if you had any problems with the order. And I never received any indication that there was a problem with the order or anything along those lines. And then there's an affidavit of non-compliance, and then that's how we ended up here, I assume.
Yes.
All right.
Yeah, they didn't even serve me with any of that paperwork saying there was a hearing or
that your conditional dismissal is an indication that the case is dismissed upon certain conditions, and those conditions weren't met.
I went and applied for some of the help with that, but I didn't know to contact you guys. I thought that the order was signed that day and that it was in effect. And I tried to get a hold of their attorney's office to get the amounts redone, and I couldn't get a hold of them and didn't know that I actually had to contact the court either. That part wasn't explained.
All right, I understand. Mr. Mashne, your response to the motion to set aside the judgment?
Well, there's 3 parts to his motion. One says he was never served any paperwork. He did sign the stipulated order for conditional dismissal. I think he just admitted that.
Right.
He didn't receive any paperwork. I think the affidavit of non-compliance was filed, and I don't think that entitles notice. I think we sent the proof of service afterwards, and when the writ was issued, the writ was probably issued before he got a chance, and I don't think that requires a hearing.
Right.
And the rest of his motion states that he's seeking help. The 30-day notice was originally filed in August of last year. My client filed the complaint in September. He hasn't received any rent at all. There's been no, and at this point, he's not interested. My client's not interested in cooperating with getting any rental assistance at this point. He just filed for an eviction. This wasn't an unpaid rent case.
All right, Mr. Kane, you did deposit 1 month rent in escrow on this motion to set aside?
Yes, they had a $650 deposit set in for that.
All right. Well, I don't think you've alleged anything in your motion to set aside my judgment on this. I don't see you entered into a conditional dismissal. That was after your initial pretrial in which you met with Mr. Mashne, and then you didn't meet the terms of the conditional dismissal.
I was trying to get the amount.
I stayed the eviction so that because I wanted to hear what did you do to rectify the situation once you understood that the conditional dismissal did not meet your need, and that's why the law says you can wait 3 days for a conditional dismissal. But I don't see that. Okay. I don't see that there's any. I don't see that you did anything in this regard.
Yeah, it's like I was waiting on the paperwork from the court, because for the conditional dismissal and stuff to take over to DHS and St. Vincent de Paul, and I didn't get that.
Mr.
The day
Kane,
of the filing, the clerk printed that out.
All right, Mr. Kane, I'm not going to set aside the possession judgment. I'm denying your motion today. We need a date certain that you'll be out.
Just a second here. Let me get into my calendar here. Hang on, my phone's being stupid.
The law indicates that I can make it 10 days of my date of signature. But I think it'll work better if we all know what date, and we're looking at the next 2 weeks, I would think.
Yeah, that's what I was trying to count out where.
Yeah. So I mean, I'm willing to work with you on getting you some time to get out of there, but I think the time has come for you to seek other April 7th, 1, 2, that's 3 weeks.
Yeah, can we have it April 3rd, because April 7th is a Friday, we wouldn't be able to file it.
All right, I'll make it April 3rd.
All right.
Oh, the denied motion to set aside default judgment. And we have a new, and you'll follow that up with an order, Mr. Mashney, just so, but I'm gonna put it for the record. April 3rd is the move out date.
Okay, I'll submit an order. So the motion to set aside the writ
is denied.
is denied.
Right, and then April 3rd at 4 o'clock. April 3rd at 4 o'clock will be the vacate and possession date. All right, so April 3rd is your date for the record, Mr. Kane, and then Mr. Mashley will follow it up with an order to that effect. It's April 3rd at 4 o'clock, okay, sir?
Okay.
So after 4 o'clock, we can file the writ?
Correct. Actually, you can, that's the date, that's the actual, that'll be the 10th date.
Yeah.
So that's the date, so you can file it before that. You can, as long as you file it 10 days before that. Let's see, 10 days. Because it's 10, it'll be, so it's whatever the 10 days are before that, because that's the date he's got to be out.
Okay, but if he's not out, I can file a writ.
Yes, absolutely. You're right. Yep. Yeah. But I think we agreed on the same thing right there. Yep. All right. Anything else for the record in docket 22-03-203, Mr. Mashney?
Just the, he's got a deposit in there.
Oh, escrow to go to the defendant so
Back
yeah.
to the defendant?
Yeah, no, back to you, to the plaintiff. So, Mr. Kane, the escrow that you've placed on it'll go towards the back payment. So escrow to plaintiff.
All right, now put that in the order.
All right, thank you. Anything else, Mr. Kane, on docket 22-03-203?
No.
All right, we'll, April 3rd at 4 is your date. That's all for the record in that file. Thank you, sir.
Thank you.
Okay. And Mr. Kane, you're all set.
Right.
Breakdown. Mr. Woodrow, you're back on docket 22-03-924.
We are, Your Honor.
All right. So we're back on the record docket 22-03-924. Mr. Woodrow, did you have the opportunity to speak with Mr. Kozert and Mr. Murray in a breakout room?
I did, Your Honor. And Mr. Kozart and Mr. Murray are asking for 2 weeks to vacate. We're obviously asking for immediate possession. He's had over 3 months to get his affairs together and vacate. So we're somewhere between tomorrow and 2 weeks. And my concern is, Your Honor, if we give him the 2 weeks, it's going to take me at least another week to submit the writ if he doesn't vacate, and probably another week after that to get a court officer out there. So in giving him 2 weeks, I'm afraid we're actually giving him 3 or 4.
Right, right. Well, I think a good date at this time would be 2 weeks. Does seem, and that place is red tagged. So I mean, that's part of the whole deal here. But I want to give Mr. Murray a chance to get his belongings and get everything and get out. So let's make it, would parties agree by the end of the week this week? So by March 24th at 4 o'clock will be the vacate date. And then Mr. Woodrow, the city can come in there and, do whatever the city needs to do. But I think that expedites this in a matter that really needs to be expedited, in my opinion.
I appreciate that, Your Honor.
All right, so let's set it for right now. The vacate, that we do have a vacate date of March 24th at 4 o'clock for the tenant to provide possession. And then let's just set a control date, just to make sure that this is, whether we need it or not or is another thing. But I want to make sure that Mr. Murray's out by 4 o'clock, not only because it's been red tagged and it's not habitable.
It is habitable.
Well, I mean, that's a matter of semantics, Mr. Murray. Okay, that's whether a place is habitable or not is all semantics. What the city has said is it's red tag, so you shouldn't be in there. So I think giving you till the 24th at 4 o'clock is really safe for you and safe for the city.
The city has given me a right of appeal to the red
all
tag.
right. Well, you're welcome to appeal it, Mr. Murray. You're welcome to appeal it, but by March 24th, by Friday, you should deliver possession from a place that is uninhabitable and doesn't have any electricity. All right.
It has electricity.
You're the last tenant in that building. All right. March 24th at 4 o'clock, and a control date of. Let's see. We'll do a control date of March 27th at 8:30. Just to keep an eye on this case, because this case appears to be significant in regards to making sure that everybody's safe. All right. Anything else, Mr. Woodrow, on docket 2203-924?
Would you like for me to submit an order to this effect, Your Honor?
Please, and make sure Mr. Kozer takes a look at it. I understand there may be an appellate process here, but we've got it. Time is of the essence here. So, Mr. Kozer, anything else on 2203-924?
No, Your Honor.
All right. All right. So we're set for March 24th at 4 o'clock right now. And then we've set a control date for the Monday after that, just to keep an eye on the file. That's all for the record, 2203-924.
Thank you, Your Honor.
Thank you. And then Mr. Chisholm, did you have the opportunity to speak with Ms. Murchison in a breakout room?
I did, Your Honor.
And did anything come out of that?
Judge, when I went to the breakout room, I know that Ms. Murchison had indicated in her motion that that she was, had attempted to make payments. And with respect to the motion itself, as I'm sure the court's aware, MCR 2.603 D1 requires good cause and a meritorious defense. And I think, the good cause portion, given what she's going through, I wouldn't be shocked if the court found that. But Ms. Murchison's not denying the fact that she owes the money. This, I think, was more about wanting to make sure that there was a payment plan in place or something like that. However, after having talked with her and learning of her situation at the moment, it is my opinion that a payment plan isn't appropriate at this point because she's not working, and she doesn't have any funds coming to her that are that can be attached by a creditor. The funds are coming in, are exempt from garnishment, or exempt from a creditor's tax. So I don't think a payment plan is appropriate at this point for her. I informed her that I thought that the proper thing for her to do was to file a motion for installment payments when she returned to work. And that was my opinion that I offered. And obviously I informed her I wasn't trying to give her legal advice, and I'm not her lawyer and everything, but that's
Right.
in my opinion, that was what I would do if I was in the circumstances she was in.
All right. And Ms. Murchison, you can unmute yourself. Is that the plan? I'm willing, I'm willing to find good cause to set aside the default, but is that the plan at this point in time? Is to really turn this into some type of installment plan, payment plan situation once you get the funds that you're able to make some payments in this? You'd have to file a motion for installment plan purposes, but the outstanding debt, it would seem to me that the outstanding debt, and it's, if I read this correct, it's somewhat significant. I've got 6,000.
Judge, I apologize. Got to switch screens here and take a look.
Right.
But that sounds about right. It is an auto deficiency case. My eyes are getting so bad. It looks like 664247.
All right. Is that the plan, Ms. Murchison? Is to file a motion, and you can go on the court's website and get a motion to make installment payments and really turn this and I'm willing to set aside the default if you're, I'm going to set aside the default anyway. I think there's enough evidence here for me to indicate that the default is not necessary. So I'm going to grant your motion to set aside the default. But I do think that this needs to be some type of collections process once you're in a position to make some payments towards the debt. Would that be a fair statement, Ms. Murchison?
Yes, sir.
All right. So Mr. Chisholm, how do you want to proceed? I think that I'm gonna grant the motion.
Judge, I guess that leaves us in the position that I guess moving forward, I would either have to work out a consent judgment with Ms. Murchison or file a motion for summary disposition. Because I think the issue here, and I guess the reason I would argue against setting it aside is that I don't think there is any meritorious defense to it. I think Ms. Murchison seems to agree that she owes the money, and
right.
And what I guess what I would say is that this already is a no interest account. It's usually with my clients, I usually go in and I as kind of part of the bargaining process in a consent judgment, we'll waive interest on this. For whatever reason, interest has already been waived on this account. And I don't know if that's conceivably somebody, if it was just policy or if somebody had decided that after, reviewing the notes or speaking with Ms. Murchison that it wasn't appropriate to charge interest in this. But anyway, the interest is not accruing on this at all. So I guess, if the motion's granted, it puts me in the position where I have to file, I either have to, Ms. Murchison and I either have to agree to it, or I have to bring a motion for summary disposition before the court.
Right. But I guess that's the motion to set aside the judgment for lack of payment. There's no question. I was looking at this as that she didn't receive notice for a hearing, but I don't have. So that was incorrect on my part.
Your Honor, Ms. Murchison was served personally with the complaint, the original complaint. And I understand that she was probably, there was, and having spoken with her, we spoke, we had obviously a prolonged conversation where I got to kind of understand the position that what she's going through. I certainly, if I was in those same shoes with what she's been dealing with, Orbit leasing wouldn't have been on the top of my, front of my, plate either. It would have been a kind of a back burner issue for me as well. But again, I just, I don't think that there's any, I don't think there's any doubt about whether the money's owed. It's just trying to, limit that impact while she's, while she's in the position she's in right now.
Right. Well, so I'll deny the motion to set aside the judgment. Deny it. I'm going to deny the motion to set aside the judgment. And then the rest is really a collections issue, Mr. Chisholm, in regards to Ms. Murchison setting up some type of plan once she's able to make some type of payment. I guess that's how the court sees it.
Judge, that's how, I was thinking that when we went in the breakout room that, the appropriate thing to do would be to set up an installment payment plan right now. I think the reason, I think there's a very good reason not to do an installment payment plan right now, because I don't think her budget allows for payments given. And again, because there's no, that the income that she has coming is exempt anyway. I don't think it's appropriate to ask for an installment payment plan for somebody who's on a very, very tight budget and can't be collected from, can't be forced to pay anyway. So I don't see the upside for her in entering into an installment payment plan at this time. It's again, just my opinion.
Right. I agree. All right. So Ms. Murchison, what I've done is I've denied the motion to set aside the judgment at this time. The judgment is still out there. It appears you've had a notice. I don't see a failed to appear here. I do know the understanding that you can't pay right now. That's part of the issue. So this really goes into a collections bucket, so to speak, in regards to payment, which it already is. And then I guess, Mr. Chisholm, I'll let you take it from there, but I'm going to deny the motion to set aside the judgment. Judgment is still valid. And then I guess you can work from there, Mr. Chisholm.
I'd be, as I expressed to Ms. Murchison, we'd be happy to work out a payment plan. I told her, first come to us, try to work out the payment plan when she does go back to work prior to filing the motion, and I let her know that the motion was the kind of, was the ultimate way of dealing with this if she's not able to work out a reasonable plan, with Orbit.
Right. So Ms. Murchison, the debt's still valid. I've denied the motion to set aside the judgment. Do you have any questions of me today?
No, I don't.
All right. If once you're put in a stable working environment where you're able to, I would contact the collection agency or the Orbit, and I would set up a plan so that something's coming in at this time. Right now, it's still a collections issue. Okay, Ms. Murchison?
Yes.
All right. Anything else for the record in docket 22-02631, Mr. Chisholm?
No, Your Honor.
All right. We're all set on this file. Thank you both for your appearance today.
Thank you. And good luck, Ms. Murchison.
Thank you.
You're all set, Ms. Murchison. All right. Ms. Lamp, is Mr. Cashbaugh going to join us today?
I'm here, Your Honor.
Oh,
Yes.
Oh, there you are. You're the iPhone. All right.
Yes.
All right. So we're on the record in docket 22L2765901. That's City of Lansing versus Todd Cashbaugh. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
And good morning, Your Honor. Jennifer Lamp appearing on behalf of my client, Todd Cashbaugh, who's also present by Zoom.
And sir, you are Todd Cashbaugh?
Correct.
And you can hear me all right, Mr. Cashbaugh?
I can.
All right, this is the time set for a second, looks like a second pretrial. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. Cashbaugh will be accepting responsibility to the amended charge of breach of the peace.
Is that the misdemeanor or civil infraction?
It's a civil infraction.
Civil infraction, $150 fine. Is that your understanding, Ms. Lamp?
Yes, it is, Your Honor.
And you'll be accepting responsibility of that civil infraction on behalf of your client?
Yes, Your Honor.
All right. The maximum, the penalty for that that fine is $150. All right, ma'am?
Okay.
So I'm just so we're on the same page. I'm gonna make sure so we're on the same. I'm gonna make sure we have the ticket that we're looking at. This is the ticket L2765990 that it's on or about December 21st, 2022 at the offense location of the City of Lansing, Ingham County on St. Joseph Highway. You're taking responsibility that your client, Todd Cashbaugh, was in breach of the peace on that date?
Yes, Your Honor.
All right, and I'll assess a $150 fine. Does your client need some time to pay that, ma'am?
Judge, I was going to ask if he could have 45 days to make that payment, please.
Any objection to 45 days?
No, Your Honor.
All right, so 45 days from today's date. All right. May 1st? All right. So May 1st at 4 o'clock will be the 150 payment will be due to the City of Lansing. All right, Ms. Lamp?
Yes, Your Honor. Thank you very much. And thank you, Ms. Williams.
Thank you.
All right. So we're all set on docket L22 L2765901. Anything else, Ms. Williams?
Your Honor.
Anything else, Ms. Lamp?
No, thank you, Your Honor.
All right, Mr. Cashbaugh, good luck to you. You're all set.
Thank you.
Yes. Yeah. All right.
I'll talk to him.
Mr. Crea, are you represented today?
By myself, I believe, Your Honor.
All right. Would you like the opportunity to speak to the assistant city attorney on your case?
No, Your Honor.
All right.
I can't even believe.
All right, we're on the record, Mr. Creer. In your case, we'll call 23 L2763111. That's City of Lansing versus Spencer Correa. Will the parties please introduce themselves for the record?
Your Honor, Assistant City Attorney Manny Williams appearing on behalf of the City of Lansing.
And sir, you are Spencer Correa, is that correct?
Yes, Your Honor.
All right, and Mr. Correa, you're not represented by counsel today, and you've indicated that you want to represent yourself?
Yes, Your Honor.
All right, and I've also given you, questioned you as to whether you'd like to talk to the Assistant City Attorney who's amenable to talking to you. Have you indicated that you did not want to talk to her?
Correct, Your Honor.
All right, Mr. Correa, then how did you want to proceed today for your pretrial?
If there's a way we could possibly come to an agreement or a solution today.
Yeah, why don't I do this? That's part of the reason to talk to the city attorney is to see if there's something to negotiate. That would be the charging agency, and they can explain to you how they look at this type of case. Maybe I'll put you in a breakout room with her so you can talk to her.
I'd appreciate it, Your Honor. Sorry about that.
All right. No worries. This process is a different process. So hang tight, and we might call some cases in front of you, and then I'll place you in a breakout room with her. Okay.
Thank you.
All right.
I
want to ask you what you do today.
know. I'm just drained today.
So we're on the record in docket 23-00720. That's the City of Lansing versus Mallory Way. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Manny Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Way, who joins us via Zoom.
And that's you. And ma'am, you are Mallory Way?
Yes, sir.
All right, and you can hear me all right, Miss Way?
Yes, I can.
This is the time set for a pretrial on this case. Miss Williams, how are we proceeding?
Your Honor, I'd like to ask for an adjournment for 45 days for compliance purposes.
That's correct.
45 days. All right, so I will grant the adjournment for 45 days for compliance purposes, but we're getting nudged by scale that we're taking too much time on some of these cases.
Okay.
This isn't one of them, but
Okay.
you know, we're getting nudged.
This is the case. This is the courtroom that moves cases the fastest.
Shockingly, I know.
By a lot.
Yes. But but I'm going to grant it 40, but just know that we're doing a little balancing act here. But adjourn for 45 days for compliance purposes is granted, and we'll set it out May 1st again. Okay. That's 45 days. Okay. Yeah, May 1st. Say May 1st, 2023 at what time? 9 o'clock. All right, so we've adjourned for compliance purposes for May 1st, 2023 at 9 o'clock. Ms. Way, anything you need to do, get done before May 1st, all right? Because
Yes, Your Honor.
Yeah, I'm going to be under a time constriction here to make sure that this 40, but the initial request is granted, all right? And please keep in contact with your attorney, Ms. Sutter, in regards to this case, all right?
Yes, Your Honor.
All right. Anything else on the record in docket 23-00720? Ms. Williams?
No, Your Honor.
Ms. Sutter?
No, Your Honor. Thank you.
All right. I'll see you again on May 1st at 9 o'clock. All right, Ms. Way?
All right. Thank you.
All right. Thank you. That's all for the record in 23-00720.
Dawson, White Thompson.
And we can do Dawson,
I thought she said White.
White Thompson. Dawson, White Thompson.
Yes.
So we're on the record in docket 23-00742. That is City of Lansing versus Dawson White Thompson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amani Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Dawson White Thompson, who joins us via Zoom.
And sir, you are Dawson White Thompson?
Yes, yes, Your Honor.
All right. You can hear me all right, Mr. Thompson?
Yes, Your Honor.
All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. White Thompson will be accepting responsibility to the amended charge breach of the peace.
Amended charge.
That's correct, Your Honor. I will be accepting responsibility on his behalf.
And that's $150 fine. It will be the ultimate. That's the fine in this. All right. Is that your understanding, Mr. White Thompson, that you'll be your attorney Lauren Sutter will be accepting responsibility for the civil infraction of breaching the peace in for you?
Yes, Your Honor.
All right. All right. So Ms. Sutter, just so we're working from the same ticket to make sure that this is a March 7th, 2023 at the offense location of Jolly and Cedar in the city of Lansing. Dawson Eugene White Thompson did in the amended civil infraction was in violation of breach of the peace in the city of Lansing. Do you admit responsibility for your client to that?
I do.
All right. What's your ordinance number for that? Do you have an ordinance or?
It is, change pages. MCL 750.170.
170. Okay. And does your so I'll accept the responsibility on the civil infraction for breach of the peace. And does your client need some time to pay the $150 fine?
Yes, he does, Your Honor.
30 days?
I suspect a little bit more than that, Your Honor.
Right.
He is homeless and dealing with CMH.
All right. So Mr. Dawson White, we'll put it out till May 1st.
Thank you.
So May 1st, 2023 to pay the $150 fine. You got that, Mr. White Thompson?
Yes.
You have till May 1st to pay the $150 fine in the city of Lansing.
Yes, Your Honor.
All right. Anything else for the record docket 23-00742, Ms. Williams?
No, Your Honor. Thank
Anything,
you.
Ms. Sutter?
Other than Mr. White Thompson, I'll send you an email later today with information on how to pay. I have nothing else for the record.
All right. So you're all set, Mr. White Thompson. You're free to leave the Zoom courtroom.
Thank you, Your Honor.
Thank you. And Ms. Robinson, you had a name. Who were you ready to?
Mr. Mitchell.
Mr. Mitchell, Margaret Mitchell.
And I'm also ready on Williams. She's at 9:30.
So we're on the record in docket 23-00407. That is City of Lansing versus Mark Mitchell. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amani Williams appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
And Mr. Mitchell.
He's in jail. That's him.
And sir, you are Mark Allen Mitchell? Mark Anthony Mitchell.
Mark Anthony Mitchell.
And Mark Anthony Mitchell, you can hear me all right?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. Mitchell will plead to the charge and I will tell Brew in return for time served.
That's correct, Your Honor.
So plead to the misdemeanor charge. And kill Brew time served. And do you have the amount time served on that? What'll that be?
I can look that.
What's he got in now, I guess?
Six days. Oh, actually, it's from 14 days. But I think he PR'd after 7, so 7 days.
All right.
I've been,
All right. Mr. Mitchell, is that your understanding that you're going to plead to the charge and that the Killebrew is going to be time served as far as jail time? Is that your understanding, Mr. Mitchell?
yes, sir.
All right. And Ms. Robinson, may I inquire of your client of his misdemeanor rights?
You may.
You understand that this is a 90-day misdemeanor and or is it what's the fine on this? $100?
I believe it's 500.
500. 257.324. So it's written under the state statute.
It's 90 days and or 500.
90 days under 500. So you understand, sir, that the ultimate penalty that the court could impose is 90 days and or $500.
Yes, sir.
All right, and there's an agreement that you're to serve no greater than the Killebrew time served. At this time, we have 7 days jail time as time served. You understand that if I went over that, you'd get to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. This is a misdemeanor, so I'm gonna read you through some of your misdemeanor rights in this case. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question any witnesses brought against you at trial. You, of course, are represented by public defender Erin Robinson. She would cross-examine or contest any charges brought against you. You have the right to have the court order any witnesses brought to your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give a claim the plea was a result of any promises other than the Killebrew agreement or threats that it was not your choice to plead guilty. You'll also not have any appeal rights because you'll be pleading guilty. You will not have any trial appeal rights because you'll be pleading guilty to the case. It's my understanding that you wish to waive your rights and plead guilty to the misdemeanor. Is that correct, sir?
Yes, sir. Yes, sir.
Okay. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm gonna bring your attention back to February 1st of 2023 at the offense location of East Kalamazoo on Pennsylvania Avenue in the city of Lansing. Were you in the city of Lansing, Ingham County on Kalamazoo Street in Pennsylvania on that date and time?
Yes, sir, Your Honor.
And at that time, did you furnish false information to a police officer with a motor vehicle involved?
Yes, sir, Your Honor.
Okay. Any questions on the factual basis, Ms. Williams?
No, Your Honor.
Any questions on the factual basis, Ms. Robinson?
No, Your Honor, thank you.
Okay, I find the factual basis and the plea to be understanding, voluntarily, and accurately made. Is there any objection to immediate sentencing today?
No, Your Honor, no objection.
Ms. Robinson,
No objection.
all right. So the court will assess a crime victim's rights fee of $75. A state fee of $50. And then a fines and costs.
Actually, I would ask maybe if you would consider waiving those,
Okay.
just because of the fact that he doesn't have an out date right now. And he's got some other open cases in multiple different courts. So I would just ask if you would.
What's he incarcerated on right now? Just out of.
So he has a felony here in this court. He's got some stuff going on in 55th.
right.
And then he also has a felony in 54B.
So I'll set it, I'll waive fines and costs in this case. We got $125. So just take CMC. So at this time, we'll administratively close the file. And that just leaves it for collections, right? All right. All right, so I have ordered pursuant to statute $75 crime victims' rights fee, $50 state fee, $125, and then I've administratively closed the file. Anything else for the record, docket 2300407, Ms. Williams?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Mitchell, you're all set on this file today, okay, sir?
Thank you.
Thank you. Anybody else?
I am ready on Ms. Williams.
Williams.
At
Are
9:30.
you ready on Miss Williams?
I think I am, yeah.
You tell me.
Oh, okay. No problem. All right.
And is Miss Williams in the courtroom?
She is.
All right.
And if he comes back, we gonna fix this. All right. I'm sure you're
Oh, okay, making sure that didn't fall first, thank you. Listen, I'm having a day of grace.
Oh.
It reminds me that I should have done it.
You can come stand up next to me.
All right, so we're on the record in docket 22-03094. That is the city of Lansing versus Tatiana Christiana Williams. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant City Attorney Emmanuel Williams appearing on behalf of the city of Lansing.
Aaron Robinson, Assistant Public Defender for Ms. Williams.
And ma'am, you are Tatiana Williams?
Mhm.
Is that a yes?
Yes.
All right, thank you. This is the time set for a pre-trial on the matter. Ms. Williams, how are we proceeding?
Your Honor, I'd like to ask for 30-day adjournment for compliance purposes.
All right, this is set for, this was the initial pre-trial set. This is a file and an accompanying ticket. Is that your understanding, Ms. Robinson, is the 30-day adjournment?
It is, Your Honor, thank you.
Okay. All right, the court's adjourned the file and the accompanying ticket to April 17th at 9 a.m. Ms. Williams, you'll get a notice of hearing of that date, okay, ma'am?
Okay.
Please keep in contact with your attorney, Ms. Robinson, in regards to that date. Anything else for the record in 22-03094, Ms. Williams?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, you're all set, Ms. Williams.
Thank
You
you.
should you'll get a notice from, if you stand by, you'll get a notice from my court officer.
Okay. Do you want to put me in a breakout room so I can talk to him very quick?
Right, with Mr. Korea?
Yeah.
All right. So, Mr. Korea, we're gonna put you in a breakout room with the assistant city attorney and you can talk about your case, all right?
Yes, Your Honor. Thank you.
All right. All right, Mr. Dumont, you're gonna meet with your public defender in a few minutes, all right, sir? Spencer Dumont, you'll have to unmute yourself.
Okay, yeah, thank you. Okay, cool.
Okay,
I appreciate that.
all right. All right, I'm gonna put you, once Miss Sutter, your public defender joins us, we'll play, you're probably already in room 1.
I'm hanging out in room 1, I think.
Okay,
Thank you.
so we'll move you to room 1, Mr. Dumont.
Should have been done that. So basically nothing. All that, and they just want to keep stressing me out over that.
They're trying to find the easiest way.
To make it nothing, which would have just been like carrying on.
We're on the record in docket 23 L2763111. That is Spencer, City of Lansing versus Spencer Korea. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
And sir, you are Spencer Korea, and you have to unmute yourself, sir.
Yes, Your Honor.
All right. This is time set for a pretrial in this matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. Korea wants to plead to the charge as is failure to display a valid license.
To display a valid license. And that's a misdemeanor?
That's a misdemeanor, 0 points under MCL 257.311.
It's 90 days under 500?
It's a 100.
Okay. 90 days under $100. Mr. Korea, is that correct? You're going to plead as charged to the license, the misdemeanor license to fail to display a valid license. It's a 0-point offense, but it's punishable ultimately. The most you could get is 90 days under $100. Do you understand that, sir?
Yes, Your Honor.
And it's your wish today to plead guilty to that?
Yes, Your Honor.
All right. So I'm going to walk you through some of your rights you'd have in this case. If your plea is accepted, you'll not have a trial of any kind. You will be giving up the following trial rights: to be tried by a jury, to be presumed innocent till proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You have the right to counsel. You have that right to have the court order any witnesses that you may have appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim. The plea was a result of any promises other than the plea agreement, if there was any, and it's not your choice to plead guilty. You'll also be giving up any appeal rights to a trial since you won't be having a trial. Is it my understanding today that you wish to waive those rights and plead guilty to the misdemeanor fail to display a valid license?
Yes, Your Honor.
All right, and so I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Okay, I'm gonna bring your attention back to January 30th of 2023 at the offense location of North Street on Large Street in the city of Lansing, Ingham County. Were you driving on North Street and Large Street on January 30th, 2023?
Yes, Your Honor.
And at that time, did you fail to have a valid license on that motor vehicle?
Correct, Your Honor.
And that motor vehicle was a 2006 Subaru?
Yes, Your Honor.
All right. Any questions on the factual basis, Ms. Williams?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. Any objection to immediate sentencing
No
today?
objections.
All right. So I'm going to go to immediate sentencing today. This is a 0-point offense for fail to display a valid license. And I'm not going to put you on probation or anything. So there'll be no jail. Crime victims' rights fee of $75 has to be assessed. A state fee of $50 has to be assessed. And then I will put a fines and costs in this matter at $75 for a grand total of $200 on this case. Do you need some time to make that payment to the city of Lansing, Mr. Korea?
I could pay it by Tuesday, Your Honor.
All right. So when you say Tuesday, let's do it by the end of the week, just to give you time, just in case. All right.
Perfect.
All right. So we'll say payment of the $200 is due by March 24th at 4 o'clock. And you can pay that in person on the 6th floor, or you can pay that online to the city of Lansing. All right, sir?
Yes, Your Honor.
All right, Ms. Williams, anything else on ticket 23L27631110T?
No, Your Honor. Thank you.
Mr. Korea, you're all set. Make the pay off that fine by the end of the week of the 24th. All right, sir?
Yes, Your Honor. Y'all have a
All
wonderful
right.
day.
You too. You're all set. Thank you for your appearance today.
Thank you.
And then so we're on the record in docket 22L2707662, City of Lansing versus Spencer Dumont. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Dumont, who joins us via Zoom.
And sir, you are Spencer Dumont?
Correct.
All right. And you can hear me all right, Mr. Dumont?
Yes.
All right. This time set for a pretrial in the matter, just as being overly cautious. I know someone in the family, and then my court reporter knows somebody in Mr. Dumont's family pretty well, as neighbors or associates.
Our daughters were very good friends.
Their daughters were friends. Any
Wendy.
objection to the court proceeding in this case, Ms. Williams?
I have no objection.
Ms. Sutter?
As long as Mr. Dumont has no objection, I do
All right.
not.
Mr. Dumont, do you have any reluctance or objection to the court proceeding? Although we know at least a court reporter knows part of your family.
No problem.
All right. With that understanding, this is a pretrial matter. Ms. Williams, how are we proceeding?
Your Honor, I would like to ask for an adjournment for 45 days for compliance purposes.
Okay, 25 days for
That's correct.
compliance. And that's correct, Ms. Sutter?
It is.
And that's May 1st? What time? 9 a.m. All right, Mr. Dumont, I've adjourned this for 45 days to May 1st at 9 a.m. Make sure you can take care of any compliance purposes that you have before May 1st and keep in contact with your attorney, Lauren Sutter, in regards to this case. And then we'll see you again on May 1st. All right, sir?
All righty. Sounds good.
Anything else, Ms. Williams, on ticket 22L2707662?
No, Your Honor, thank you.
Ms. Sutter?
No, Your Honor, thank you.
Okay, you're all set. You're free to leave the Zoom courtroom. Thank you for your appearance today, Mr. Dumont.
Thank you.
And then Mr. Vamosathet.
Yes.
So we're on the record in docket 22-03547. That's the city of Lansing versus Jaden Vamosathet. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Vamosathe, who joins us via Zoom.
And sir, you are Jaden Vamosathet?
Yes, Your Honor.
And you can hear me all right, Mr. Vamosathet?
I can.
All right. Ms. Williams, this is the time set for a second pretrial on the matter. How are we proceeding?
Your Honor, my understanding is that Mr. Vamosathet will be accepting responsibility to the amended charge of impeding traffic. That's under MCL 257.676B.
What's the fine on that?
$130.
$130?
I mean, it's just-
All right. So is that your understanding, Ms. Sutter, that the defendant will be pleading to an amended count of impeding traffic, a civil infraction under 257.676B with the $130 fine?
That's correct, Your Honor, and I will accept responsibility on his behalf.
All right. So we're working from the same ticket. That's ticket 225191201 that on December 22nd, 22 at the offense location of the city of Lansing, Butler, and Ionia, that Mr. Vamosathet was impeding traffic on that date. You accept responsibility for the civil infraction in this case, Ms. Sutter?
Yes, I do.
All right. With that understanding, we'll set a fine of $130. And does your client need some time to make that payment?
I believe so, Your Honor, at least 30 days.
Mr. Vamosathet, will 30 days work in regards to making a payment to the city of Lansing?
Yes.
All right. 30 day out would be 17th or 24th, something around there.
We get to choose. I prefer the further update than the earlier one.
It would actually be the 16th, so the 17th, since the 16th of April is that next Sunday.
17th, all right. So April 17th. All right, so Mr. Vamosathet, April 17th, your payment will be due to the city of Lansing by April 17th. You can make that payment in person on the 6th floor or online. All right, sir?
Okay, thank you.
All right. Anything else for the record? Docket 22-03547, Ms. Williams?
No, Your Honor.
Ms. Sutter?
No, Your Honor, thank you.
All right, thank you. You're all set, Mr. Vamosathet.
Okay, thank you. Have a good day.
You too. So let's go ahead and call Miss Barrera. No, we've got two. We've got Barrera and Marshall.
Okay, I was just making sure.
Let's do Barrera first. And I think Miss Barrera was here and then she failed to appear or something else. I can't remember.
She didn't show for the
All right. So we're on the record in docket 21-02617 and 21-02618. That's City of Lansing versus Maria Barrera. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Karen Robinson, Assistant Public Defender for Ms. Barrera.
This was initially set for 10:15. I'm sorry, it was originally set for 9:30. It is now 10:15. It would appear that the defendant has failed to appear. I would note that defendant failed to appear last week on a preliminary examination. Ms. Williams, how would you like to proceed?
Your Honor, I'd like to request a bench warrant bond forfeiture with a 48-hour.
All right, Ms. Robinson.
No comment.
All right, I do know that Ms. Barrera has failed to appear previously on a preliminary examination, so I'm going to indicate a fail to appear with bench warrant bond forfeiture. Okay. Anything else for the record in docket 21-02617 and 618, both City of Lansing cases? Ms. Williams.
No, Your Honor.
Ms. Robinson.
No, Your Honor, thank you.
All right, thank you. And then I think we have a marshal.
Yes, I have a Viote Marshall.
One of the Iman. Let's try Miss Marshall first. So we're on the record in docket 21-00044. Aviote Jabre Marshall, City of Lansing versus Aviote Marshall. Will the parties please introduce themselves for the record?
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
I do have that as a church case.
We're trying to figure out.
But you're
these notes.
Yeah, it looks like we're on the case. Karen Robinson, Assistant Public Defender for Mr. Marshall.
All right. This is the time set for a pretrial in the matter. It was 9 o'clock. It was set for 9 o'clock. It's now 10:17. It appears that the defendants failed to appear on a, I think this is a ticket. This is a 1 misdemeanor, no license applied, and registration and no proof. Defendants failed to appear. Ms. Williams, how do you want to proceed?
Your Honor, I'd like to request a bench warrant bond forfeiture with a 48-hour hold.
I do have this as the first fail to appear, so I will indicate a bench warrant bond forfeiture with a 48-hour hold. Any comment on that, Ms. Robinson?
What? I'm sorry.
Any comment today on this on the Marshall case?
No, Your Honor.
So we've issued a bench warrant bond forfeiture with a 48-hour hold. That's all for the record in that file, which is 21-00044. Isn't that the one I signed a?
Let me check.
I think I signed something on that. I did sign it. I just don't know.
Did you sign it this morning, you mean?
I think I signed it last week.
Okay, then we'll look for it.
No problem. It's ticket, so.
We did this person 2 years ago.
Oh, I thought she talked to me.
Yeah, these guys. Yeah, we will find it.
Let me see if this is. Bill. 180.
Have you signed it was in my office and I just didn't get to it.
All right.
We had kind of a crazy and it's possible.
These are, so these are the 1 o'clocks or 11 o'clocks.
Yeah.
All right.
And we're out. Now that you say, or nothing you mentioned that the building burns, I kind of remember it. I think I was trying to find it.
All right. Yeah, I think that sounds right. So I, Miss Williams, I think that's all we have for right now for the city and for.
Checking, to see if Ms. Steenbeck applied for the public defender.
Who did?
Ms. Sarah Steenbeck. She's scheduled for a final pre-trial. She was represented by Mr. English before he withdrew his appearance.
Okay.
Remember that case?
So I'm just gonna not, I'll just scratch out off.
I'm sorry, I should have gotten it. Oh, she voted? Yeah. Put her on the bench. Thank you. Yeah. Good chance. Is it on the document?
Mr. Woody, you're here on Miss Pereira.
Yeah, I'm here a little early.
Yeah, give me a few minutes, well, till 11, but I think I just issued my 3rd bench warrant against her. So
I just don't want her to show up, get arrested.
I agree.
That cycle repeats.
If she shows up, she's getting arrested because she was a no-show on a prelim last week. And then she was also and then she was a no-show on 2 cases today.
My goodness.
So yeah, but I'll probably call her at 11. She's on her. Exactly.
Have a good day.
We'll see you, Miss Williams. All right, Miss Skeltis is here. How about LaRose?
For what?
So Miss Skeltis, you're here on the 10 o'clock, Melanie LaRose and Mark LaRose?
That is correct, Your Honor.
All right. So I don't see the LaRoses here in the courtroom. We'll give them till 10:30 and then we'll see where we go, okay?
Sounds good, Your Honor. Thank you.
Thank you. Oh, it is a 10:50. Well, I'll call them all at once. That's earlier than I thought. I can actually call them right now. Let's see what Mr. Dua, you're here on, you've also got 2 10 o'clocks. You got Miss Week and Miss Dennis?
Yes, correct, Your Honor.
All right. And would the individual on the cell phone please identify yourself? 896-1068.
Asia Dennis.
Say it again, ma'am.
Asia Dennis.
Your Honor, that's Miss Dennis, which is one of my 10 o'clocks, and I just sent in a kind of last minute dismissal on that
All
one.
right.
She's all paid up.
All right, let me grab that file then. That's 564. And we just got, I just got that in front of me, so.
Perfect.
Order to dismiss. This is 3. All right, Miss Dennis, you're all set today, all right? You're free to leave the Zoom courtroom. The case against you was dismissed by order and I just signed it, all right, Miss Dennis?
Thank you so much.
Thank you, you're all set.
Bye-bye.
And then Mr. Dude, we can actually just go ahead and call these 10 o'clock. So you have a Jessica Week also?
Yes, Your Honor.
All right. So we're on the record in docket 23-00563. It's Carolina Apartments versus Jessica Week. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning. Sam Dua here on behalf of plaintiff.
All right, this is the time set. It was set for 10 o'clock. It is now 10:23. It appears that the tenant has failed to appear. I will note for the record that on March 8th, this was also the tenant failed to appear on that date. Mr. Dua, how would you like to proceed?
Thank you, Your Honor. First off, I would like to note for the court's record that apparently there was a small typographical error on the summons and complaint. I believe the defendant's last name is actually Weck, W-E-C-K. If the court could please take note of that.
All right.
And further, Your Honor, plaintiffs would move for a default possessory judgment to enter. I have those amounts ready if you'd like me to state them for the record.
Please.
Thank you, Your Honor. Rent to retain possession amount $6,244. Costs in the matter $164.84, totaling $6,408.84 to be paid on or before March 30th, 2023 to prevent order of eviction from issuing.
And you'll follow the follow-up with an order to that effect?
Of course, Your Honor. Thank you.
All right. So anything else? So I have $6,408.84 to vacate date of March 30th, 2023. Order to follow. Anything else on docket 2300563, Mr. Dua?
Nothing further, Your Honor. Thank you.
All right. That's all for the record on that file. And then Ms. Skeltis, I'll go ahead and call. Docket 2300552. And that is Wilmington Savings Fund versus Melanie LaRose and Mark LaRose. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Marla Skeltis appearing on behalf of the plaintiff.
All right, this was initially set for a hearing at 10 o'clock. It is now 10:26. And it would appear that the tenant has failed to appear. I don't see Melanie LaRose or Mark LaRose in the Zoom courtroom. I don't see him in the physical courtroom. I will take notice that the tenant previously failed to appear on March 8th at 10 o'clock. Ms. Skeltis, how would you like to proceed?
Your Honor, I would request a default judgment with the writ to issue on or after March 30th, 2023.
And did you want to put any numbers on the record, or did you just want to follow that up with an order?
Your Honor, this is a post foreclosure summary
Correct.
proceeding.
Right. Right. All right. So March 30 vacates. And I'll sign the order when I get it in this regard.
Thank you, Your Honor. Is there an email address that I can send that to?
There is. The email for the court orders are Judge Flores courtroom at lansingmi.gov.
Great. Thank you, Your Honor.
All right. Thank you, Ms. Skeltis. Thank you for your appearance today. We're all set.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
We put a bunch of FTAs this morning. So, Mr. Gann, we'll call your case on docket 23-00578. That's H Incorporated versus John Doe and Jane Doe. Will the parties please introduce themselves for the record?
May it please the Honorable Court, Steve Gann, P 78219 for the plaintiff.
All right, this was the time set for a formal hearing in the matter. It was set for 10:15. It is now 10:41. It appears that the defendants have failed or tenants have failed to appear. I will note for the record that tenants had failed to appear on March 20th at 10:15. Mr. Gann, how did you want to proceed?
At this time here, I would like to move for a default on this matter. This facts behind this, these are squatters, unknown names to the manager or to the owners of the property. The owners were notified by utility company that they have circumvented the gas utility so that they cannot turn off the gas, and so they're now stealing utilities, for lack of a better word. But at this point, we need to get them out of there. So I'd move for a default on this matter that I can send over to the court today.
All right. So the court will await the order to catch up with the file today. I'll sign it this afternoon. Anything else on the record? Default judgment is orally granted. Anything else for the record? Docket 23-00578. Mr. Gann.
No, sir.
All right. Thank you for your appearance today. Have a nice day.
Thank you. Have a great day. And your staff as well.
Thanks. And then Mr. Dua, I think we're ready to call your case on 23-00566 LT. That is Carolina Apartments LL versus Ikhlas Ramadan. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
And this was the time set for formal hearing. It was set for 10:15. It is now 10:43. It appears that the defendants failed to appear.
Hi, sir. My name is Ikhlas Ramadan.
Are you Miss Ramadan?
Yes, I am. I'm sorry about that. I was unable to find the meeting ID.
All right, so Ms. Ramadan, I have you here for the formal hearing. You had failed to appear previously on March 8th. Do you recall getting a notice on that date by attachment?
So the reason why I didn't attend is only because the same day that the Zoom meeting was stated, I received it the same day. So because I moved to a different city, I'm guessing the mail came very late. So the same time.
So
that
you don't.
Yeah.
You don't live at that Lansing Risdale address anymore?
No, I do not, sir.
Mr. Dua, do you want the opportunity to speak with Ms. Ramadan in a breakout room?
Yes.
I
Yes,
don't know. I don't know your case, but she indicates she doesn't live in that residence anymore.
I believe that would primarily resolve our case, Your Honor, if I could just speak with the defendant shortly.
All right. Ms. Ramadan, I'm going to place you in a breakout room with a legal representative of Carolina Apartments, Mr. Dua, and you can talk about some of the issues in this case, all right?
Okay, thank you.
All right. I'm going to have Mr. Dua and Ms. Ramadan placed in a breakout room. Oh, Mr.
Yes,
Dua, do you need your property manager?
That would be great. Simtab Property Management.
Is that Simtab?
It is.
All right. Mr. Bates, 568. I don't see Gene Rainey. All right, so we're on the record in docket 23-00568. That is Wells Fargo Bank versus Gene Maynard. Will the parties please introduce themselves?
Good morning, Your Honor. Aaron Bayless, P78234, appearing on behalf of plaintiff.
All right, and I do not see Gene Maynard in the Zoom courtroom. I do not see him in the physical courtroom. This was set for 10:15. It is now 10:45. It appears that the tenants failed to appear. I do have a previous failed to appear on March 20th at 10:15. No, I'm sorry, on March 8th This was set for March 20th. It was March 8th at 10:15. Mr. Bayless, how would you like to proceed?
We were requesting entry of default judgment with a move out date of March 30th.
And you'll submit an order to that effect?
Yes, Your Honor. Just to confirm, I believe my previous sister counsel requested the email address. It is Judge Flores Courtroom at lansingmi.gov.
Correct.
Excellent. I will have my staff submit a judgment today.
All right. Anything else for the record? Docket 23-00568, Mr. Bayless.
Nothing further, Your Honor.
All right. Thank you. You're all set. Thank you for your appearance today.
Thank you very much. You have a wonderful day.
You too. So how much does you working on it? You knew what I was gonna ask.
I was just switching screens.
Osborne and
Oh, you gotta be kidding. This is a 10 case?
yeah.
$260. Let me just administer my closes. Half of that may be beyond my ability. A huge chunk of this is to the external collections that we used to use their payment fee.
Let's see what, yeah, I think that's Judge Felice. How about Raymond?
Yeah, this is another super old one. Yeah.
Mr. Dua, did you have the opportunity on 23-00566 to speak with Miss Ramadan?
I did, Your Honor.
And how are we proceeding today?
Thank you, Your Honors. The defendant has indicated to me that she vacated the premises on January 14th, 2023. She no longer wishes to return. She does have some items in the unit, but she says that she's willing to relinquish those items and relinquish possession today. I think probably the best thing to do is to enter into a consent judgment today with the rent to retain possession amount and giving the 10-day opportunity to collect the items.
All right.
Should she desire.
Miss, yeah, you'll have to unmute yourself. Ms.
Yeah.
Ramadan, did you want to do that? That'll give you 10 days to collect any personal property you might want to grab from there.
Okay, so I did speak to him, and I did tell him that I moved out in January. Now does this offer me like an opportunity to receive my items without being like I don't
Yeah,
know,
I
it's
think
like,
I think that's Mr. Dua's plan is to introduce it. Is that your plan, Mr. Dua, to enter into a conditional dismissal, and that'll provide about 10 days for her to get her stuff?
You know, Your Honor, in this case, with her being vacated for so long and her expressing to me that she does not want to return, I would prefer to do a consent judgment with the rent
Oh,
to
I'm
retain
sorry.
possession amount and the pay to stay date of March 30th, 2023.
March 30th. I'm sorry, that was my fault. Okay, so if you enter into a consent judgment and you're no longer in the residence, that'll give you 10 days to get your stuff any personal property out, Ms. Ramadan. Is that how you want to proceed?
is there like a certain fee if I get my items? Is there like is there anything that would
Mr. Dua,
happen?
is there any cost to her for getting her items?
No, as a matter of fact, there could be potential cost to her for not removing her items later down the road.
So Ms. Ramadan, as long as you get your items out of there, I think you'd avoid any potential fees.
Okay, so okay, that sounds good.
All right, so you'll submit a order for consent judgment, Mr. Dua, and go ahead.
Will, Your Honor, may I just put those amounts on the record, please?
You sure can.
Thank you, Your Honor. Proposed consent judgment would indicate that the rent to retain possession amount is $6,385.08 with costs of $164.84 in this matter, totaling $6,549.92 to be paid on or before March 30th, 2023 to prevent order of eviction from issuing. In the alternative, the defendant can simply remove her items and turn in keys prior to March 30th, 2023, also to prevent order of eviction from issuing.
I have a question. He told me that there will be no fee or claim to this. So
I think since you're already out, that's what you're saying, Mr. Dua, correct?
Correct, Your Honor. I think she's confusing the money judgment portion, which was not paid for or paid for in this case with any sort of fee.
Right. So since you've already vacated the property and they're looking just to possess it, the March 30th date is really the amount of time you have 10 days to get the rest of your property out of there. All right, Ms. Ramadan?
okay, and what are the fees? Like I'm a little confused. So he told me there's two options. He told me that there's an option if I get my items, I'll be charged over $6,000, and the other option was
No, you're already out. So, and as long as you get your items in the next 10 days, there'll be no additional fees. Is that correct, Mr. Dua?
Correct, Your Honor. Ms. Ramadan, if, as I told you in the breakout room, if for some reason you decide tomorrow, all of a sudden that you want to stay and you want to come back, then you would have to pay that $6,549.92. If you don't, then simply please just come back within the next 10 days, retrieve your items and turn in your keys to management prior to the 30th.
okay. So I just have one thing. So the keys I threw away only because I didn't intend to come back and I was endangered for my safety. I have no intention to ever come back to Lansing ever in my life. I had too many bad experiences.
Well, then
So
if you
that's-
could simply mail them a letter saying that you have retrieved everything that you need and that you're out by the 30th, then that would be great.
I did email them, and so the Carolina Apartments, they emailed me regarding it, and I emailed them back telling them I stated the date, and I told them I moved out on that date and everything. So, and I left them voice messages also.
Okay.
All right. You may want to mail them in regards to the property that's still in, because I think they're there's some concern about the property still in there. They want to make sure that you've retrieved any of the property or that you're leaving that property. And if you have anybody who can come and retrieve it, that might save you a fee of them cleaning up whatever property's there.
Okay, all right, that sounds fine. Yeah, that's
All right.
okay, possible.
All right, Mr. Dewitt, you said you'd follow that up with an order to that effect?
Absolutely, Your Honor. Do I have the defendant's permission to sign that order on her behalf?
Mr. Ramadan, do you give Mr. Dua permission to sign that consent judgment based on what that order is really based on what we have spoken about concerning 10 days to get your stuff out, no additional fees?
Yes, that's fine.
All right. Anything else for the record? Docket 23-00566, Mr. Dua?
Nothing from plaintiff, Your Honor. Thank you very much.
Mr. Ramadan, do you have any questions of me?
Regarding the fees and everything, you said it's due by the 30th, or I'm not.
Yeah, as long as you get your property out by the 30th, and you write them and tell them that the keys no longer exist, you should be fine.
Okay. All right. Thank you.
All right. Thank you. That's all for the record in 23-00566. And then, Mr. Dua, I think we have you most of the afternoon.
Correct, Your Honor. I'm also in your courtroom covering for Mr. Herman's, Attorney Herman's office as well.
So that means you're on every case this afternoon.
Lucky you.
All right. We'll see you this afternoon.
Thank you, Your Honor. I'll see you in just a little bit.
All right. And then, Mr. Whitty, I will give 3 minutes because we should, but I don't. Miss Barrera is already, as you know, has a myriad of cases with us already that she's failed to appear on. New felon. I think we can go ahead and call her. Let's. So we're on the record in docket 22-04153. That is Michael Christie versus Maria Barrera. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Norman Whitty appearing on behalf of Michael Christie, who's also present in the courtroom.
All right, this is the time set for a second hearing. It's actually set for formal and then a second formal hearing. I will indicate at the last formal hearing, Ms. Barrera showed up. She had outstanding warrants. She had a felony warrant. She's taken into custody. She has since then failed to appear for preliminary examination of last week. And then we bench warranted her on 2 additional warrants today. So I would indicate that this was set for 10:45. If it is now 10:58, the defendants failed to appear, or tenants failed to appear. And Mr. Whitty, how would you like to proceed?
All right, this time I'd like to request entry of a default judgment. If I may approach, I have a default and a judgment form to present.
And you may. Thank you. Thank you. And let the record reflect that I'm signing the judgment landlord tenant and the default judgment. And then if you want any copies of that, you can, Nathaniel will make copies for you. But both are signed. Anything else for the record? Docket 22-04153, Mr. Whitty.
Nothing further, Your
All
Honor.
right, thank you. There's the file. So we're all set. It's always good to see you, Mr. Whitty.
Thank you, my pleasure.
And Miss Ramadan, you're free to leave the Zoom courtroom when you want to. Okay, ma'am?
Okay, thank you so much. Have a great day, sir.
Okay. You too. So we're on the record in docket 102278. That's the city of Lansing versus John Osborne. It is March 20th. This was scheduled for 11 o'clock. It's now 11:17. But after review of this file, it appears that that this 2010 Judge Felice case, we're going to administratively close the file. All right, so ACMC on the outstanding debt. That's all for the record on docket 102278. We have 2 tickets. Listen to this. 2 tickets on, are you okay? A docket 186832421 and 19L2L250862. That is, and it is set for, this is a show cause on an outstanding debt. This was scheduled for 11 o'clock. It's now 11:18. And it appears that the defendants failed to appear. And I'm going to issue a bench warrant and bond forfeiture on both.
So can you do those and I do this?
Yeah, so that's Mr. Lewis on his 2, and then we'll probably do the same on the expired meters. So on the record in docket TT21005082 and TT2201262767. That's City of Lansing versus Scott Lind. This was initially set for 11 o'clock. It is now 11:19. Defendants failed to appear. Bench warrant and bond forfeitures issued. These are 2 expired meters that have now gone to warrant. So that's on the record on docket TT21005082 and TT22012667. All right, we're on the record in docket 22-01692. The city of Lansing versus Madison Mowry. And ma'am, you are Madison Mowry?
Yes, Your Honor.
All right, this is the time set for a probation violation arraignment. And so what we'll do here is I'll tell you the nature of the arraignment charges brought against you, and then we'll go from there. It is alleged that you violated probation. This was on a request and summons for probation violation on March 3rd, 2023 by Jody Bayless, countersigned by a judge on March 6, 2023. It's alleged that you violated your probation in the following manner: that you committed the following technical probation violations, and that you failed to refrain from alcohol as directed per Avon Health on February 24th, 2023. You tested positive for alcohol, and then you yielded results per Avon Health in regards to that test. So that is the nature of the allegations that have been brought against you. You have a right to a hearing in this matter, and you have the right to counsel. A hearing would be set sometime within the next 2 weeks. The right to counsel would be either retained by yourself or would be a public defender, as you had under the underlying charge. It looks like the public defender's office represented you in the underlying charge. Is that correct, ma'am?
Yes, sir.
All right. Do you plan on retaining the public defender's office for this charge, for
No.
this probation violation charge?
No, I do not.
You don't?
No.
So did you just want to set this for hearing today? Let's see, you pled to a count 1 and you dismissed count 2. So the maximum penalty on the count 1 is 6 months in jail and or $700 fine. And it looks like at sentencing you agreed to no upfront jail. So those are in the court's discretion. So it is your choice today to set this for formal hearing in regards to this probation violation?
Well, no, then yeah, I would like to
You want to talk to a lawyer?
Yes.
All right. So the public defender's office, do you have something to write down their number with? You're gonna have to make application to the public defenders. It's not the same as it was in the underlying case. You'll have to talk to them about the hearing date that we're going to set it for, and the actual formal hearing date.
Yes.
So let me make sure you have the number, their number. And their number is 517-679-2979.
Okay, I got it. Thank you.
517-679-2979. Explain to them that your violation's been has been violated, and that we've set it for formal hearing date, and I'll give you a formal hearing date. So probation arraignment was arraigned, and we'll set it for formal hearing date on April 3rd. So it's set for formal hearing date on April 3rd at 1:30. And so you should make sure and give the public defender's office that date, April 3rd at 1:30,
Okay.
for the date of the hearing. All right.
Okay.
All right. You have any questions of me, Ms. Mowry, on 22-01692? We've set it for April 3rd at 1:30.
Nope.
And you'll be reaching out to the public defender's office in this regard, okay?
Yes, sir. Thank you.
All right, thank you. That's it. You're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
Sir, on the Motorola G, would you please identify yourself and you'll have to unmute yourself? You,
Jared Bogan.
Jared Bogan. All right, Mr. Bogan, you're here for your 215.
Yes, ma'am. Yes, sir.
All right, you're in the right place. I'll call your case after in a few minutes. All right, I got some 2 o'clocks in front of you, and then I'll call your case.
Okay. Thank you, sir.
Thank you.
Mm-hmm. Oh. Hmm? I'm glad I'm moving. Good moving.
Judge, you can't.
Sir, on the cell phone, can you identify yourself on the Moto GPR? You just joined?
Clayton Dawson.
Clayton
It's Clayton
Dawson.
Dawson.
Okay, you're here for your 2 o'clock?
Yes, sir.
All right. Stand by and we'll call your case in just a second. You're in the right place.
Okay. Thank you. No. Hard for you guys to tell her what you want. Absolutely. Things I want to talk about. And she watches. So how,
On the cell phone, are you Mindy
Caparelli, yes.
Kaporal? All right. And you're here for your 2 o'clock, ma'am?
Yes.
All right.
She can log off on her other device.
You can go ahead and log off on your other device. As long as we can talk to you on the cell phone, you should be fine.
Okay. All right. So I should log out of this?
Yeah, the laptop, you can probably, because we can hear
Hello?
you on the cell phone.
I got rid of it.
All right, and then I'll call your case when the
Hello?
lawyers gets here, okay?
Hello?
Ms. Kaporal, we'll call your case in just a minute, all right?
Oh, okay. Okay. All right. Thank you.
All right. Yes, Ms. Caporal, we're still waiting. Ma'am, are you there? On your phone? So, yes, we're still waiting and we'll call cases in just a minute. I think the other one might be a fail to appear. Mr. Dawson, let's put yours on the record, okay?
Okay.
So we're on the record in docket 22-04013. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
And sir, you are Clayton Dawson?
Yes, sir. Clayton Dawson.
Okay, all right. Mr. Dewitt, this is the time set for a formal hearing, and you indicated something for the record?
Yes, thank you, Your Honor. I had an opportunity to meet with plaintiff's agent in the hallway, and it's my understanding that Mr. Dawson made a payment today, and management has agreed to waive the remainder, putting him to a zero balance, which would provide for the case to be dismissed without prejudice today.
All right, so the case is dismissed without prejudice. I think you'll follow that up with an order?
Yes, of course, Your Honor.
And Mr. Dawson, you're all set today, okay?
All right, I appreciate it.
All right, thank you, Mr. Dawson.
Thank you.
All right.
And then that's for plaintiff. And then did you want to talk to Miss Caporel?
Yes, I probably should. The only thing that I'm concerned with on that case, Your Honor, is plaintiff and plaintiff's agent are here today, ready to testify per your orders. And if nothing is resolved, then we will need a hearing today.
Yeah, and I'll go ahead and allow you to put on proofs and explain to her what's going on.
Thank you, Your Honor.
All right. So, Ms. Caporal, Ms. Caporal, have you had the opportunity to speak with Mr. Dua about this? Because this is the time set for a hearing today. Ms. Caporal? No, we can't hear you, ma'am, and we could hear you when your phone was on through your phone. Why don't we call your other case? I think that's a fail to appear, I think.
Actually, I think that's with me.
Is that Mr. Presley?
No.
Ford.
Are you able to hear me now? Hello?
Yes, we are able to hear you now, Ms. Caporal.
Okay.
Ms. Caporal, this is the time set for a formal hearing live. And I think I actually indicated that we were to have a formal hearing live on this date. Ms. Caporal, are you there?
Yes, I'm here. Can you hear me?
Yes, I can. So
okay,
we're supposed to have a formal, well, yeah, let's Ms. Caporal, this is the time set for a formal hearing. Would you like the opportunity to speak with Mr. Dua, who is a representative of the landlord? He's got witnesses here, and you may want to talk to him.
yes, sure. Yep.
All right, if you join up.
Thank you.
Yeah.
Your Honor, would you like to take the Ford case so that Mr. Kazort is free? We just have a brief thing to put on the record.
Sure. So
hello,
which case is that?
Timothy.
All right, Ms. Caporal, we're going to place another case on the record, and then I'm going to put you in a breakout room with Mr. Dua. Ms. Caporal, we're going to place another case on the record, and then I'm going to put you in a breakout room with Mr. Dua, okay?
Thirty-four, 33. Yes, correct.
So we're on the record in docket 22-03433. That's Holmes Apartment LLC versus Timothy Ford. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua on behalf of plaintiff.
Adam Kazort here on behalf of defendant.
And this is the time set for a hearing on this matter. Mr. Dua, how are we proceeding today?
Thank you, Your Honor. I have had an opportunity to meet with Mr. Kazort on behalf of defendant Ford, and it appears that the defendant is unable to catch up, and an extended time to vacate the premises has been allowed. A conditional dismissal has been proposed. We have not drawn it up yet. We can draw it up and submit it later to the court, but it would simply state the defendant agrees to vacate the premises and turn in keys to management on or before April 14th, 2023.
And is that a correct statement, Mr. Kosor?
It is accurate, Your Honor. We should have that today or tomorrow.
Okay. So the conditional dismissal will be drawn up indicating date of vacate is April 14th?
Correct. Your Honor.
Anything else for the record in docket 2203433, Mr. Dua?
Nothing further, Your Honor.
Kosor?
Nothing.
All right. So April 14th is date of vacate, and we'll wait for the order to catch up with the file.
Thank you, Your Honor.
Thank you.
Would you like to do 3432, or would you like me to speak?
Let's do 3432 while we're.
Thank you, Your Honor.
So that is.
Thanks, Adam.
Presley. And we're on the record in docket 2203432. That is Holmes Apartment LLC versus Brandon Presley. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
And this is the time is set for a formal hearing in the matter. It was scheduled for 2 o'clock. It is now 2:24. It would appear, I don't see Mr. Presley in the Zoom courtroom. There's nobody in the physical courtroom. It would appear that the tenants failed to appear. I will indicate that the tenant failed to appear on the January 25th date for pretrial, and that's why we set it for formal hearing. Mr. Dua, how would you like to proceed?
Thank you, Your Honor. Plaintiffs would move for a default possessory judgment to enter. Rent to retain possession amount $5,111.07. There were $164.84 in costs in this matter, totaling $5,276.02. Payment must be made on or before March 30th, 2023 in order to prevent order of eviction from entering. And I do have an order prepared for you if I may approach.
You may. Thank you, Mr. Dua. Okay, for the record, I've signed the order for the court file. Anything else on record 2203432, Mr. Dua?
I do have a default affidavit for you.
Yeah,
Your Honor.
let me sign that. And then if you want a copy of it, Mr. Neves will give you a copy.
Thank you.
Thanks. Anything else for the record? 2203432, Mr. Dua.
Nothing further, Your Honor. Thank you.
You're all set. You can get a copy of that from Mr. Neves. I'm gonna, if once you join, I'll put you in a breakout room with Ms. Caparel.
Thank you.
Ms. Caparel, are you there? All right, you can just talk to me on your phone. You don't have to join on the other device. Ms. Caparel, can you hear me on your phone?
I can, right now I can, yes.
All right. Do you have a problem? as soon as Mr. Dua joins us, I'm gonna put you in a breakout room with us, okay? With him, okay?
Miss Caporal, can you hear me? Hello? Wait for him to put us in a breakout room, I guess.
Yeah, I'm gonna put all of you in a room, Sam, and see what happens, all right?
Hello?
Mr. Bogan, we're still here. We've got one of the your attorney is in a breakout room. So when he gets out, we'll call your case.
Okay, thank you.
You're welcome.
What's up, Scary? How you doing? Hey. I'm on court right now. Court. You gotta say this. What's the wrong with this? I can't smoke on here. I gotta go.
Failed to appear. 3434.
Yes.
So we're on the record in docket 22-03434. That is a MLK Apartments versus Christy Rendon. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
This is the time set for a formal hearing today, and it appears that Ms. Rendon, let's see, this was scheduled for 2:15. It's now 2:45. I've checked the Zoom courtroom and Ms. Rendon is not present. Checked the physical courtroom and Ms. Rendon's not present. All parties appeared on January 25th for that Zoom meeting. I do have live in person. It appears that the tenants failed to appear. Mr. Dua, how would you like to proceed?
Thank you, Your Honor. Plaintiffs would move for a default possessory judgment to enter. Unfortunately, I do not have the numbers prepared for you right at this moment, but I would be happy to supplement with the default and default affidavit in about 10 or 15 minutes.
All right. Ordered. All right, so the court will wait signing the default and the default order in this regard. So that's all for the record docket 22-03434. Ms. Caparel, are you there? Ms. Caparel?
I gave her my phone number. She texted me and said that her Uber's coming in just a few minutes and she'll be on the way.
All right. All right. She sounds like she's running here. And then Mr. Bogan's been on. Let's call that case. He's been patiently waiting. So Mr.
Just grab the manager.
All right.
Just in case. Okay, sorry.
No, that's fine. So we're on the record in docket 22-04014. That is Holmes Apartment LLC versus Jared Bogan. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff. With me today is the manager of Holmes Apartments.
Thank you. And sir, you are Jared Bogan, and you'll have to unmute yourself. You'll have to unmute yourself, sir.
Yes, I am.
All right, this time set for a formal hearing in the matter. Mr. Bogan, you are not represented by counsel, is that correct?
Yes, yeah, no counsel.
And you are prepared to go to formal hearing today?
Yes.
It didn't sound very convincing, Mr. Bogan. Have you had the opportunity to speak with Mr. Dua, who's a legal representative of Holmes Apartment?
I did the last time, but not this time.
Okay, well,
Oh, Your Honor, if I may.
you may.
I did have an opportunity to speak to the defendant last time. I see here at my notes that the defendant was, we attempted to do a conditional dismissal, but it was too premature because it was only at the pretrial.
Right.
And if it's still the defendant's intention to pay the entire balance by March 31st, 2023, I am prepared to drop the conditional dismissal to that effect.
Is that still your intent, Mr. Bogan, is to leave by March 31st?
Or pay the balance.
Or pay the balance?
Yeah, well, I'm waiting on my taxes to come back. So it was gonna be the 15th.
Do you want to talk to him?
Yeah, that'd be great.
Yeah. Mr. Bogan, I'm going to place you in a breakout room with Mr. Dua, and you can discuss some of these legal issues, and then we'll put it back on the record, okay?
Okay.
All right. So once you join.
Got it. Yeah, sure.
Yeah.
You're the decision maker.
Yeah, I feel all this shit.
Thank you, Your Honor.
All right. Thank you, Mr. Dua. All right, Mr. Bogan, once Mr. Dua joins the room, we'll place you in a breakout room.
Okay, thank you.
You're welcome.
This should take forever. My court date was at 2:15. That's 2:50. You went over to Canitas? Oh. I think she still stay out there. I tried her. She didn't answer. I was over here. I was going to my grandpa's house. Let me see where we go. All right. You already know. Get the hell out of here. All right. My friends with you on Facebook? Huh? My friends with you on Facebook? I think so.
All right, we're back on the record in docket 22040414. Mr. Dua, did you have the opportunity to speak to Mr. Bogan in a breakout room?
Yes, Your Honor. Thank you. I did. Mr. Bogan and I discussed, and unfortunately, the tax return that he's expecting is not coming until April 15th now, and that was not sufficient for landlord to be able to enter into the conditional dismissal. However, we have come to terms on a proposed consent judgment. If I may put those terms on the record.
Absolutely.
Thank you. Proposed consent judgment would indicate that the rent to retain possession amount is $5,685.
The car is clean. Why you doing that?
Mr. Bogan, we can hear you. So are you talking to us or somebody else
Oh,
there?
sorry about that, sir.
All right. So $5,685 is the rent to retain?
Correct. $163.86 in costs, totaling $5,848.86, which must be paid on or before March 30th, 2023, in order to prevent order from eviction from issuing. In the alternative, which is the more likely case, the defendant is simply going to vacate the premises and turn in keys to management prior to that same date, March 30th, 2023.
All right. And Mr. Bogan, that's your understanding of the consent judgment?
Yes, sir.
All right. And did you want to put us on the record authorization to sign his name to that, Mr. Dua?
Yes, may I inquire the defendant?
You may.
Thank you. Mr. Bogan, as we discussed in the breakout room, and as I just put on the record, you need to pay $5,848.86 on or before March 30th, 2023. Alternatively, you could simply vacate the premises and turn in keys to management. I have a piece of paper here that says exactly that I'm going to present to the judge. May I please affix your signature to that document to make it binding after the judge signs it?
Yes, sir.
Thank you. May I approach, Your Honor?
You may.
Thank you.
Okay, so for the record, I am looking at a consent judgment, landlord tenant, of the numbers previously discussed. And I am signing that document. And then a copy of that will be provided to Mr. Bogan, and Mr. Netz can provide you a copy of it. Anything else for the record, docket 22040414, Mr. Dua?
Nothing further, Your Honor. Thank
Mr.
you.
Bogan, you should be all set. I've signed the order, okay?
Okay, thank you.
Oh, thank you. You're free to leave the Zoom courtroom.
All right.
And then is there a Antoine Trainer? All right. So Mr. Trainer's here. So this is set for formal hearing today. So you can speak with Mr. Dua if you'd like on that. And then we're waiting for Mr. Caporal is in a Uber. And then you have Miss Crawford. Those are the three.
Here.
Yes.
Thank you, Your Honor.
What's that?
Oh, I think we have McMullen. McMullen, we do, yeah.
And McMullen is Mr. Kozerts. We can place that on the record right now if you'd like.
That's fine. And then
Yeah,
that'll be easier.
Yeah,
we've worked a fair number of these out.
right.
What, do I need to do anything?
Yeah, you. 4, 3, 3. All right. So we're on the record in docket 22-03430. That's people of the state of Michigan. I'm sorry, that's KPW Management versus Kenneth McMullen.
Yes, sir.
Sorry, sir.
That's okay.
Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
Your Honor, Adam Kazord here on behalf of Mr. McMullen, who is sitting to my right.
And sir, you are Kenneth McMullen, correct?
Yes, sir.
All right. This is the time set for a formal hearing today, and I'm in possession of an appearance from Legal Services of South Central Michigan, along with some defenses in that they asked for a jury trial date, a jury trial demand in this matter. Mr. Dua, how are we proceeding today?
Thank you, Your Honor. I suppose we would be proceeding by moving it to Your Honor civil docket.
Right.
And hopefully that'll give Mr. Kazort and I a chance to hammer this out.
So move to civil docket, and what's our jury trial? Do we set that or does that? So that's all. So you'll get a jury trial date from the civil department in this. But this is, so we're awaiting the civil jury trial date. And then in the interim, I'm sure Mr. Dew and Mr. Kozort will be talking about or negotiating through this case. Anything else for the record in docket 22-03430, Mr. Dua?
Nothing further. Your Honor.
Anything,
Thank
Mr. Kozert?
Nothing further, yeah.
All right, so we're all set and we'll get a new date. So you're free to leave. You're free to leave this courtroom, sir.
Thank you.
You're all set.
Yeah.
You too, Mr. McMullen.
Yes, sir.
It's more of the utilities issue than anything else. It's utilities. I believe so.
Oh, okay.
I think I signed a dismissal on that.
It's between section 8 and utilities and probably some back downs. He hasn't paid his downs in a little bit. So, yeah, it shouldn't be that bad. Yes. Wonderful. I will, Miss Crawford is outside. So why don't you come outside with me and when we talk to her, we can. Instead of running back. Yeah. Sorry about that. Thank you, Ron.
Thank you.
I'm working on that.
Sorry, your name again, please?